So my topic is preparing to patent. What can you do before seeing an attorney? Okay, just a little bit about myself. So as I mentioned, I'm from New Zealand. I'm actually a mechanical engineer and a lawyer, as well as a patent attorney. And I work with a lot of large and also small companies. I do a lot of work in the startup scene. It's a real passion of mine. I know that startups have, they lack money, so it's a real challenge to protect what is often their one and only asset, which is their intellectual property. They're working in shared space, they lease their computers, they don't actually own any assets other than their intellectual property. And so protecting that is pretty important. I also lecture for the World Intellectual Property Office on patent drafting. Some of you may be familiar with WIPO. They administer the PCT program. So I'm a partner at a firm called AJ Park in New Zealand and in Australia. And we have been around since 1891, so a long, long time. I've been practicing IP for 23 years. We employ about 220 people, and we do primarily patent and trademark law. Okay, so that's a little bit about my background. So as I mentioned, this talk is about the things you can do before you go and see a patent attorney. But what is a patent attorney? I thought I'd address this question to start off with. So a patent attorney is, it really just depends on which country you're talking about. But really, a patent attorney falls within the broader umbrella of being an IP advisor, intellectual property advisor. And within that broader umbrella, there is the term patent attorney. There are also IP lawyers, there are IP consultants, there are trademark attorneys in some countries, and IP attorneys. It really just is a little bit about terminology rather than actually the substance. So I'll explain also why you might want to go and see a patent attorney or a lawyer, an IP lawyer. Okay, so the first reason for going to see a patent attorney may be to protect your own IP. Okay, you may have come up with a new invention which may be eligible for patent protection. You may have come up with a new brand that may be eligible for trademark protection. Registered designs. You may also go and see a patent attorney to help you protect your trade secrets or to help you with confidentiality agreements. The other reason that you might go and see a patent attorney is to identify intellectual property rights of others that you may end up infringing. Okay. So this is really important. It's called freedom to operate. Do you have freedom to operate your business in light of the IP that other companies may own that can sue you for patent infringement or trademark infringement? That's another reason why you might go and see a patent attorney. They can also help you with commercializing your intellectual property. Okay, so at AJ Park and also at Borsum, Stephen here from Borsum, they'll be doing licensing work. So you've come up with a new product, but you don't really want to start a manufacturing business. You may end up licensing your IP, your product, to a company that's better equipped to manufacture and distribute your product around the world. So you may end up doing a licensing agreement, or you may end up collaborating with other companies to help develop your technology. We can also help you with IP strategy and IP enforcement. So if someone is copying your product and you have IP rights, then a patent attorney or an IP lawyer, most IP advisors can help you out with IP enforcement. I'll make these slides available to the group here, but this is a slide that I've created to help you understand what form of intellectual property you might be looking at. Just very quickly, is your idea a brand or a product? If it's a brand, then clearly you're looking at trademark protection as the only form of IP protection that might be available to you. But if it's a product or a process, then there are potentially 4 different forms of IP rights that are available. And sometimes for some products, more than one of those forms of IP may be available to you. This is a little flowchart just to help you identify what sort of IP rights you might be looking at. So preparing to patent. I thought this is a really good topic that was suggested to me by Carl. I work with Carl, he lives here in Shenzhen. We're working with him for about 4 months to help with his IP protection. like I mentioned, startups do not have a lot of money, and so if you can prepare yourself before going to see a patent attorney, you could be saving yourself some money. Okay? So that's really what the topic is about. So patents provide protection for inventions to stop others from copying your product or process. So patents can be obtained for products, for processes, formulations, and in not all countries, but in many countries also for software. How do you get a patent? Well, you actually have to file a patent specification at the patent office. So you have to prepare a document that even for a piece of simple technology like a bicycle, let's say you've invented a bicycle, the patent specification may be 10 pages long. Okay, really strange, you know, a bicycle is a bicycle. How many pages do you need to describe a bicycle? But a patent specification performs many functions, and that is often why they can be quite long. Okay. Then once the application is filed, the patent specification is filed, the patent office will examine the patent application, and they'll determine whether your invention is unique compared to something which might have been done before by someone else. And if they approve the patent, if they say, yeah, your invention is unique enough, then you'll be granted a patent. Now, the scope of patent protection is really dependent on how unique your invention is compared to what's been done before. So I can't really file a patent for a bicycle anymore because a bicycle has already been invented. Okay. If I filed a patent for it, the patent office would say, well, you know, I can take a photo outside my office. The patent office examiner will say, I can take a photo outside my office, and I'll take 10 pictures of bicycles out there and prove that your invention is not new. So most patents that are filed these days are for improvements on existing technology. There are not really many patents being filed for things that are extremely revolutionary. So they're always just improvements, small improvements, but they may have a substantial commercial benefit over and above existing technology. The scope of a patent is also dependent on how good your patent attorney is. Okay. I see probably twice a year I'll see clients coming to see me and say, hey, I have filed my own patent application, and I will look at the patent specification and it's not worth the paper it's written on. Okay. It may only be 2 pages long. It just does not do the job of protecting the invention that the inventor has come up with. So let me explain. So the inventor has come up with a product. Okay. It may be a bicycle. Okay. As I mentioned before, there is what we call prior art, prior existing products already out there. Okay. So there may be, for example, a unicycle that someone has already been using for many, many years, and you've come up with a bicycle. It's the patent attorney's job to identify what the inventive concept in the bicycle is and file a patent specification around the concept. Okay. So the product is the bicycle, but there may be other versions of a bicycle that fall within the same concept that the inventor has come up with. And so this is the job of the patent attorney, to work with the inventor to understand what the inventive concept is in the product. And I'll explain some steps that you guys can take before you go and see a patent attorney to facilitate that process. Here's an example of the bicycle that I've invented and a patent that's been filed purely for the product. Okay. The scope of the patent is so narrow that it means that a competitor can easily make changes in design around the scope of the patent. Whereas the previous circle, the competitor would have had to make a 90% change to their product to avoid infringing my patent. But here they only have to make a 10% change to get around it. Just putting some numbers on it, just to give you some relativity there. Sometimes I see patent specifications that completely miss even protecting the product itself. Okay. So the product that the inventor wanted to be protected is the bicycle, but the patent is actually protecting something random over here. So not even protecting the actual physical product, let alone the invention or the concept in the product. So what happens when you are preparing a patent specification is that you will work with the patent attorney so that they get to understand what your business opportunities are, your invention, and its commercially important novel features. So the novel bit is about, do the uniqueness of the product. So what we're really trying to do with the inventor as a patent attorney is to identify the unique value proposition in the product. The thing that has commercial value and that is unique. This will then help form an IP strategy, which may lead to a recommendation to file a patent. But not always. Sometimes products or processes in particular are best kept as a trade secret rather than as protected as a patent. So how do we prepare a good patent specification? So you need to pick an experienced patent attorney, okay? And one that is familiar with your area of technology. So I'm a mechanical engineer and a patent attorney. Stephen from Boston is also a mechanical engineer and a patent attorney. We would never touch an invention and file a patent for biotechnology, or maybe even for software, because our backgrounds, our technical backgrounds are not in that field. So personally, I don't file patents for software inventions, for biotechnology or for chemistry. I only deal with inventors that have come up with mechanical technology, which in itself is a very broad ranging topic. You know, fluid dynamics, thermo, mechanics. A lot of my patents that I file are for packaging. I work with a toy company here in Shenzhen and file a lot of patents for toys. They've got mechanical features in them. Step 2, ask about costs, okay, because you may not be able to afford the patent process. And patent costs are spread over time. You file a patent application in one country, 12 months later you file in other countries. And you may not file in every country of the world, no one really does. You just pick countries where you strategically need IP protection. So get familiar with the costs so that you know that you can fund the patent process. Okay, step 3 is the invention disclosure. So this is for the patent attorney to learn more about the product that the inventor has come up with and to work with them to determine what should be patented. Step 4 is to conduct what we call prior art searching. So searching for existing technology. We know that we can't get a patent for things that are already out there, that are already known. So searching will help determine what is already out there. And then that'll help determine what can be patented. Okay, so we've got a wish list of things that should be patented, the unique value propositions, but sometimes those value propositions turn out not to be unique. The prior art searching is going to reveal that. Okay. And then we set about preparing the patent specification. And whilst the patent specification serves purely a legal function, if you pick up a patent specification, you'll see that there'll be a lot of technical information in the patent. Okay. Yes, I mentioned even for a bicycle, the patent specification may be 10 pages long, and I'll explain why in a minute. So the inventor is the technical expert, and the attorney is the legal expert. The inventor has invented a product, and the attorney needs to know a lot about the product to then conceptualize the product with the help of the inventor. So it can be quite an iterative process. So let's say that I've invented a bicycle, and I know that the only prior art, the only existing piece of technology is a unicycle. It's really hard to use, right? Very unstable, both laterally and longitudinally, terrible to ride. So I've invented the bicycle. Okay, 2 wheels, one front, one back wheel. The wheels, once they're in motion, gyroscopically help stabilize the bike. And it's my invention. Okay, a lot safer, a lot easier to use. But the patent attorney will talk to the inventor and say, well, 2 wheels, one front, one back is probably what the concept is that we're trying to protect. But you've also put a seat on there. Okay, kind of the same as a seat on the unicycle. But hey, you've also put handlebars on there and you can steer this bicycle. That's pretty cool. But by and large, it's got quite a few similarities to the unicycle. But what if someone else came along and made a product that looked like this? So the scope of protection for the bicycle is that circle. But then someone comes along and makes a tricycle, also inherently stable, even more stable than the unicycle and the bicycle. Okay. So the inventor will go, well, hey, yeah, that's not bad. we should try and protect that as well. Okay. So suddenly the scope of the patent that you're aiming for is a lot larger. More discussions. You realise that the bicycle could also be a scooter. Again, having the same benefits of being stable, or much more stable compared to the unicycle. Okay. And so suddenly the scope of the patent stretches even further. So you can see that it can be quite an iterative process. The patent attorney will play the devil's advocate on the information that the inventor is telling them, and we'll push the boundaries. We'll really dig deep into what is the concept that it is that you've come up with. You've given me a picture of a bicycle, but there's more to it than that. So things that the patent attorney should be asking you during this process is, well, how did you come up with this idea? What are the essential features and what are the optional features? Okay, so the essential features are the two wheels that are connected by a frame. There's handlebars, but potentially they are optional features. Okay, it's pretty useful to have a handlebar and steering of the front wheel, but arguably that's an optional feature. The handlebars may carry a bell to warn other road users that we're coming. Okay. It's definitely an optional feature. It's nice to have, but it's not really about what the invention is about. Okay, what advantages do each essential features provide? What is the interaction with other features? What are some alternative features that might achieve the same purpose? So that might then flush out the fact that this could be a tricycle as well as a bicycle. Okay. Patent attorney should ask about past failures and ask why they failed. So the trial and error process that you've been through, because that will help, again, conceptualize what the broad concept is. Some more questions that the patent attorney should ask is, well, how will your new idea be commercialized? Where? Which countries? By who? Are you going to be doing this business yourself, or are you going to be licensing it, or partnering up, or maybe even just selling your IP outright? So really, IP strategy should be the first discussion before going down the path of patent protection. Consider other forms of IP that may supplement patent protection. Maybe that your invention is better kept as a trade secret, which are a lot cheaper than patents, but they are also very vulnerable to reverse engineering or independent design, and then you've lost the benefit of that protection. Ask about IP, the patent attorney should ask about IP ownership. So who invented this? And who is to own the patent? And talk about freedom to operate, so infringement risks. Some more questions the patent attorney should ask, and these are questions that you can come prepared with to your meeting so that you can be efficient in your discussions with the patent attorney. Has there been any publication of your idea? The golden rule of patent protection for most countries is that your idea or your product needs to have been kept confidential until a patent application has been filed in one country. So that's usually the first question that I ask of a new client that comes into my office. I'll say, nice idea, but have you published this? And they may say, oh yeah, I've been selling this product for the last 5 years. And I'll tell them straight away, you can now not get a patent for this idea, for this product. It's too late. You should have come to see me before you disclose this idea. And also, when does the application need to be filed? Are you about to start selling the product? How much time have I got as a patent attorney to prepare and file the patent specification? I've had one instance where I had to prepare it in the space of 24 hours, and that's not ideal. Luckily, New Zealand is a country where we see the new date pretty much first in the world. And so I was able to do some time travel and file the patent application in the States, where it was still yesterday. Sometimes I get time travel clients coming to see me as well, but it's a different story. So do searching. So, and that's really important. Patents are about protecting the unique value proposition, but is the value proposition really unique? Because it's only the unique features that you can patent. So do some prior art searching. You may also discover from the research that your invention is old and you just can't get a patent, or that your invention may have other applications beyond what it is that you're targeting. Okay? And so maybe the patent can be filed much more broadly to target other opportunities, or to maybe license your patent to companies that are able to chase those other opportunities, and you just chase the opportunity that you're originally focused on. It may also reveal that you can improve your invention further. And if someone else has already invented a better version, usually inventions are about solving a problem. Okay? But maybe someone else has already solved that problem and has solved it better than you have. So then question the commercial value of your invention and the merits of filing a patent. Okay? If someone else has already invented a better mousetrap. Okay? So again, I just can't reinforce this enough. Do prior art searching. Okay? Because filing a patent is not cheap. You might be spending between $5,000 and $10,000 US in the first year to file a provisional application, and then at the 12-month stage you then need to take it into other countries where you want to pursue patents, and that's when the costs go up. And it may only be 4 or 5 years down the track that someone else, like the patent office, finds a piece of prior art that's identical to your invention, and then your entire patent family around the world is invalid. You spend maybe $100,000 at that stage thinking that you've got a strong patent, but one piece of prior art just kills it completely. So spending time up front doing prior art research is really valuable. And you can do this yourself. Okay? So you don't need to go and see a patent attorney to do prior art searching, and I'll show you a nice little table at the end as to how you can gather the information. So Google Patents, it's free. eSpaceNet, you just Google that or search that. And many more databases now have a collection of patent publications from around the world. Some of them go back to the 1800s. I had a client about a year ago, and he invented and I can tell you about this because it's not new, but he invented a poncho, so a rain jacket, that could convert to a bag, that could convert to a hammock, that could convert to a sleeping bag. So it's a multi-purpose poncho. And I found a piece of prior art publication going back to 1886, a US patent specification with a picture of a cowboy on a horse wearing this poncho, and then a picture of a tent next to the horse. Okay. So any publication anywhere in the world of a product that is the same or similar can have an effect on the scope of patent protection that you can obtain. So again, searching is important. So then, once you are in the process of doing the searching, create a list of product features that you believe are unique value drivers, and then search to see if someone else has already published a product with the same features. And the table that I'll show you next will explain what I mean. Realize that a patent cannot protect product advantages. So I can't get a patent for a safer way of transporting myself over a surface. Okay. I can only get a patent for the product that provides that advantage, which is my bicycle. But then I can conceptualize the bicycle to the broader concept. But it's only the features that provide the advantage that the patent can be about. So when you're doing the searching, look for prior art that has the same or similar features, not necessarily the same advantages. And the searching that you can do, you can use keywords. So the word vehicle and plural, two and wheel, and we'll get prior art surfaces in the form of bicycles or tricycles. So here's the table that I would create if I was looking to file a patent for the bicycle. So in the left-hand column are my invention features. So there's a frame, a first wheel, a second wheel. The second wheel is in front of the first wheel. Okay? So I'm drilling down to a little bit more detail. The second wheel can rotate relative to the frame so that I can steer my bicycle. The second wheel has got front shock absorbing forks. So that's an extra feature that I created for my bicycle. I thought, well, hey, this is quite cool. I can make this ride a lot more comfortable by putting shock absorbers at the front. I've put handlebars on the front wheel. I've put a seat on my bicycle, and I've put a bell on my handlebars. Okay. And in this column, this is about the purpose of each of those features. So that'll help communicate to the patent attorney why that feature exists in your product. Right. And so you've done some searching and you find some prior art in the form of a unicycle and in the form of a hoverboard. Okay, it's kind of back to front, right? Hoverboards came well after the bicycle, but this is just for illustrative purposes. So now you can, in those columns, identify corresponding features to the features in your product. And a table like this, if you're going to see a patent attorney with a table like this, having done some of your own research, can really help quickly identify what the unique value proposition is that the patent should be targeting and can be targeting because of the prior art. So remember that we have a wish list of things that we want to patent, and then the prior art will determine what we can actually patent. So in this example, the unique value proposition is there, right? The second wheel is in front of the first wheel. Because the unicycle doesn't have a front wheel. This has got two wheels, but one's not in front of the other. And it's, other than the electronics inside it that are managing the stability, it would be inherently unstable. Okay, so the patent in this situation would be to the combination of features A plus B plus C plus D. Fairly broad patent, and I'll illustrate why that is broad. Okay, we'll skip that slide. So here's an infringement situation. Okay, so you filed the patent for the combination of A plus B plus C plus D. Okay, so that's those features there, and the patent has been approved because the prior art does not have feature D in it. Okay, other people come along and they make a copy product. Okay, so the tricycle, it has a frame, the first wheel, the second wheel, and the second wheel is in front of the first wheel. It infringes my patent. My patent is so broad to capture the tricycle. Okay. The second wheel is in front. It's not directly in front, but it is in front. Okay, so that's patent. The patent world would say that that's an infringement. The scooter, again, I haven't added into my claim, into my scope of protection, that I have a seat in the product. Okay, so the claim, the patent claim, is limited to those four features, and it does not include a seat. And so therefore, the scooter would be an infringement of my patent. But this product here, it's not an infringement, okay, because it doesn't have a second wheel.
What is it?
It's a shoe with, what kids wear. Scoot along the ground with. Yeah, I'd kill myself if I use one of those. Okay. But, okay, so you haven't done any prior art searching. A patent office 4 years down the track finds, so you've done some limited prior art searching. So you found prior art 1 and prior art 2, but you haven't done a lot of prior art searching. A patent office 5 years later on finds prior art number 3, which is rollerblades, right, inline skates. Okay. You filed a patent for A and B and C and D. That patent is now invalid because of this product here. Okay. It has a frame, so there's a metal frame at the bottom of the shoe. They examined it and issued an examination report during the examination process, so pre-grant. So this table illustrates also with this new piece of prior art that there could be other things patentable, right? So the bicycle on its own, the A, B, and C cannot be patented, but possible combinations such as A, B, C, D, and E. Okay. There's a no across this row here for all of the prior art. So E becomes the novel feature. Okay. There's a bell that's also got a no across the bottom, but really is it worthwhile filing a patent for it? Knowing that someone else can make a bicycle with front shock absorbers that can steer the front wheel, but there's got no bell on it. Patent's going to be really narrow. So you've got the bell on the bicycle. Another thing that could be patentable is, and this is the discussion that the inventor and the patent attorney will have, is, well, hey, you've invented a shock absorber. Why don't you put that on the unicycle? Okay. So one of the patents could be to the combination of A and C and F. Okay. So a frame with a wheel and shock absorber, not the bicycle.
Is it possible that the bell would fail the obviousness test? That just like people would go like, duh, put a bell on your bicycle?
Potentially, yeah. Yep. The patent office would do a search for a bell and add another column here. So a bell has been used on schools. Teacher's bell at the front. And it would be obvious to put that on a bicycle. But maybe not. Right.
All right.
Thank you.